Fantastic. So I'm going to ask my fellow panelists to turn on their cameras and we're going to get started. So thank you so much for joining us today to talk about the new employment landscape. We're facing the biggest changes in a generation, the Employment Rights Act 2025. It received royal assent in December, and with everything else going on in the world at the moment, it might not have been forefront of your mind so far. But you've made a great start by joining us today. And our overall view is that there isn't anything here to terrify you, but it's very good to prepare and plan. Otherwise, you might feel you've missed some things. So I'm delighted to introduce my guests today. I've got Kate Palker, who's an employment law specialist with over 25 years of experience at the Legal Director. And the Legal Director are transforming the way legal services are delivered by giving UK businesses access to an experienced in-house general counsel. I've also got Sasha Ashton, a fractional CPO, Chief People Officer at People Puzzles, with wide experience in retail, in health, in apprenticeship and skills, as well as significant experience in a company owned by an EOT. And last but not least, I've got Mark Ratcliffe. So Mark is a specialist insurance advisor from Partners And, who focuses predominantly on professional and financial risk with a keen interest in the recruitment and staffing sector. So thank you to all of you for joining me today. As we go through, if you've got any questions or comments, please do post them in the chat box and we'll try to answer them at the end. Or if we run out of time, then by email. So we're really keen to make sure your questions get answered. So to kick off, a little bit of audience participation requested. Here is a quick quiz to test your knowledge so far. So hopefully there's a poll appearing on your screen right now. There's 3 questions. You'll have to scroll down through the questions. So first question is, how long is it expected to take for all provisions of the Employment Rights Act 2025 to come into force? So you might know that, you might not. So have a vote on that. The second question is, what is the new qualifying period for unfair dismissal protection? Again, don't worry if you don't know this, that's what today's all about, but let's see who knows already. And then the third question is, what significant change has been made to unfair dismissal compensation? So I'm just going to give you another 30 seconds to vote on that, and we'll see what you all think. So have a vote. Amazing. So great. I've got just a couple more people. You might not want to vote. You might feel I'm not quite ready. Ask me again at the end, which is also fine. Okay. So I'm going to end the poll. Last chance saloon. Okay. So I'm going to share the results with you. Can we see that? Can anybody see that? Yeah. Okay. So we've got quite mixed answers. So first question, how long is it expected to take for all the provisions of the ERA to come into force? Well, congratulations if you said up to 2 years, spot on. So they're not all coming in straight away. It's a phased introduction. So you've got different things coming at different times just to add to the fun of this. The second question, what is the new qualifying period for unfair dismissal protection? If you said 6 months, you are correct. So again, I think that was the leader, but we've got quite mixed views on that one. And then the third question, what significant change has been made to unfair dismissal compensation? Well, the compensation cap has been removed. So I think that was our best answer. 77% of people said that. So well done to you guys. If you got 3 out of 3, don't worry, we're not going to be requiring answers on that one. Okay, so let's get talking to our experts and see if we can help you during our webinar today. So, Kate, there is absolutely loads in the Employment Rights Act, and we've just found out it's going to take 2 years for it to all come in. Can you kick us off by talking to us about the 3 biggest risks you can see for business leaders?
Hi, Ellie. Sure. Thank you. So the Employment Rights Act, I'm going to call it ERA, as it's affectionately known, 2025 isn't just HR reform. It's a risk shift for boards and executives. There's masses in it, but you've asked me to summarise or give 3 main risk impact points. So here they are. The first one we've already looked at in that poll. So as we know, unfair dismissal risk arises earlier. and it's uncapped in terms of compensation. So from January 27, employees will gain unfair dismissal rights after 6 months, not 2 years, and compensation is no longer capped. So this basically means the old familiar 2 year safety net will disappear. Probation exits, restructures, TUPE dismissals, they'll all carry expanded litigation risk. And for senior staff, awards will now reflect full loss, so not the artificial ceiling, which is currently at 125,543. So in short, people decisions become open-ended financial exposure, not necessarily a manageable HR cost. The second biggest risk, I think, is that business flexibility around changing terms and restructures will be significantly reduced. The Act sharply limits fire and rehire strategies, which are used to bring in changes to key employment terms like pay and hours. And it also increases penalties for getting redundancies wrong. So the key points here will be dismissing employees for refusing contractual changes like pay and hours will become automatically unfair normally. Collective consultation, so that's over 20 people, failures in collective consultations will now trigger up to 6 months' pay per employee if you get it wrong. And consultation duties are wider and harder to avoid. So the result of this will be that restructures, turnarounds, M&A activity, changes in T's and C's will become slower, more expensive and riskier if they're not properly planned up front, which will then directly affect cash flow, strategy, planning, and resilience in downturns. And the third risk, and this is a broader risk, is that culture and governance failures will attract regulator attention. So the Act will strengthen enforcement through a new Fair Work Agency, which was established on the 7th of April, and it raises expectations around culture. So in practice, employers will actively have to prevent sexual harassment, including harassment of your employees by third parties like customers and suppliers. Harassment complaints will become whistleblowing complaints, which gives an employee who's brought those complaints significantly expanded protection. And enforcement will be more proactive and pattern-based, not just claim-driven. So this means that poor culture is no longer just a reputational risk. It'll become a regulatory and a legal risk, and increasingly a board risk. So as a takeaway on the changes, the Act doesn't just give employees more rights, it moves risk up the organisation.
Thanks, Kate. I mean, it does sound quite scary, I have to say, when you go through those all in a row. And you know, I think it was interesting, you said people decisions have maybe been an HR risk before,
Yeah,
but now it's a whole business risk.
yeah,
So it's really good to be talking about this as a
yeah,
whole today. And Kate, let's be honest, many of us have used settlement
yeah.
agreements for a variety of reasons, but really to ease that exit process. Can you remind us how they work and when you recommend that businesses use them and whether that's changing?
Yeah, sure. So settlement agreements are a very effective way for employers and employees to resolve the end of employment or a potential dispute on agreed terms. So in exchange for a payment and often a reference and other types of protections, an employee waives their rights to bring most employment claims. So this will allow the employees to avoid a difficult process like a performance process or even a redundancy process, and also gain some dignity and some control over the way that they exit the business. And the agreements also give businesses certainty in avoiding future claims and reputational risk. To be valid, the agreements have to be in writing and an employee has to receive independent legal advice, and it's normal for employers to make a contribution towards the costs of that. In terms of when to use them, they're really useful, and but especially where risk or speed or sensitivity matters. So common scenarios would include, say, senior exits, redundancy exercises with legal wrinkles like a maternity redundancy or redundancy on TUPE, or where there's a selection risk. Probation or early service exits where there may have been whistleblowing or there are protected characteristics, so there could be a discrimination claim. And then I see them used primarily where essentially there's been a relationship breakdown or a performance problem. So trust has gone, but a full process would be slow or disruptive or or legally exposed. Um, so they're particularly valuable where the legal outcome is uncertain. The key business takeaway for them is that they're a risk management tool, but they're not a shortcut. They shouldn't be used as a shortcut. Used well, they cap financial exposure, they cap reputational exposure, they avoid management time being swallowed up in disputes, and they allow commercial outcomes rather than litigation, which obviously is going to become increasingly important given what we've just said about uncapped compensation and earlier rights. So used badly, though, or as a substitute for fair process, I think they can increase discrimination and regulatory risk. So the discipline is knowing when to use them. And alternatively, it might be necessary to actually fix the underlying issue instead.
Yeah, and you hear about companies where employees expect to leave under a settlement. So there's this
Yeah,
sort of culture of expecting an
indeed. Yeah.
increased payout in any situation, which has its own challenges. Sasha, I'm
Yes.
going to come to you. I'm keen to get your take on this because I know you're often sort of broaching those difficult
Yeah,
conversations with people. Have you got any practical tips or how do you go about it?
yeah, and I think this is where businesses come unstuck, Ali, actually, because I think the conversation itself is often harder than the legal process around it, Kate, isn't
Yeah.
it, really?
Right. Yeah.
So practical steps, really. The first thing I say is don't ambush people. Yeah, the conversation about a settlement agreement should never be the first time somebody's hearing about a problem.
Mm.
And if you've been having honest performance and relationship discussions, then the settlement conversation itself becomes less of a shock and less likely to end up being contested. Secondly, I think don't have an off the cuff conversation. The language you use really does matter. And I often write clients scripts to make sure that they're using the correct language and the correct legal terms and provisions that they're actually having that conversation under. Going back to what Kate said, you're not accusing anyone of anything, you are actually asking for agreement. So it does really matter the language that you're using around that. I'd always suggest starting with something like, I want to have a confidential conversation with you about your future in the business. Nothing's been decided, but I think it's important we talk openly. And that sort of opens the door for your conversation to then continue. And then practically, never have the conversation alone. I would always say have a witness or HR in the room. Never put anything in writing before the conversation has happened, and never pressurize anyone into agreeing or providing an immediate answer, because as Kate said, they're entitled to take legal advice, and as an employer you should be encouraging them to go and get that advice. And then I guess ultimately the whole process, I would say, treat people with respect and dignity throughout the process, really. Even if the relationship is broken down, the thing that people remember will be how they were exited from the business. And I guess in the world of LinkedIn, Glassdoor, etc., your reputation really does matter, doesn't it? In the way that you exit people is almost as important as important, I would say, is the way that you onboard people. So I guess my last piece of advice would be, if you're not sure, take advice, and get support and help either from, legal advice or HR advice in carrying out the process.
Yeah, it's interesting having thought about the ERA and getting to this tricky issue of exits so early in the conversation, isn't it? Because it really does feel such a significant thing that's changing in the Act that that how we part ways with people. And I do wonder whether we'll see a sort of not a flood, but an increased focus on who we really want in our organisations between now and the end of 2026, because we've almost got this window before things are going to start getting tougher, haven't we? But let's carry on talking about the risk here. So, Mark, I know you're talking to business leaders every week, and you're also talking about risks from a different perspective. And so, can you talk to us about the insurance risks that you're seeing as the ERA starts coming into our businesses?
Yeah, yeah, in a way, Kate kind of stole my thunder there because I think she encapsulated quite a lot of what we are discussing with businesses really well. But I suppose the one thing I would add is, so just kind of putting the insurance to one side for a second, which might seem a silly thing to do given I'm an insurance professional. But actually, what I actually see a lot when I'm speaking to clients is a real lack of preparedness and a lack of awareness actually as to the scale of the changes that the Act brings in. It's not an insignificant piece of legislation. Um, and added to that, I think what's lost a little bit is all the other stuff that they've got going on at the minute. So they've got this kind of operational HR risk that's kind of being foisted upon them against the backdrop of changes in tax legislation, a lack of supply chain resilience. It's not actually lost on me. It's not an enviable position to be in to be a business leader at this moment in time because of the sheer weight of change and obligations being put upon them. But I mean, from a pure insurance perspective, the increased risk of litigation is the obvious avenue because you've got an unusual storm here where you've got the reduction in the qualifying period, increasing the opportunity for frequency. Yeah, because ultimately, you've got a population of people there who are going to be entitled to bring that claim that would not have been previously. But with the removal of the compensation cap, you've also got an increase in severity. Now, they're really boring insurance terms, frequency and severity. But if you look across insurance products, they actually underpin insurers' appetites and responses across the piece. Now, I think when you talk there about settlement agreements and making sure people are exited in the right way, I also think I also think what occasionally gets lost in the conversation is got a population of people managers there who have to be upskilled really quite quickly. That first, I think about all the jobs I've had in my career, which aren't that many actually. I shouldn't create that impression, but the reality is, if you think about that induction period, that first 6 months, in most businesses, particularly in services businesses, it's a fairly gentle induction during that period of time. It's about kind of cultural assimilation, getting to know your colleagues, and and particularly if you're going into a new job that you perhaps haven't done before, there's almost an acceptance on the employer's part that you're going to have to learn the ropes, receive the training, etc. I think it puts a real pressure on people leaders who perhaps haven't done it before to really robustly manage during that first 6 months, which is kind of counterintuitive to most people's nature, really. What people like to, they're conscious of making people feel really comfortable when they come into an organization. But one of the things I did pick up on there from Kate's overview, which, like I say, was a really good, succinct overview of quite a lot of information, is from an insurance perspective, one thing that does concern me is those increased obligations on employers in respect of harassment by third parties. Because I think from an insurance perspective, that's a difficult risk to encapsulate, because it's a difficult one for me to position with insurers that somebody else is going to be responsible for the conduct of somebody who's not under their supervision, or at least can be held liable if they've failed to kind of do the appropriate level of due diligence. But just theoretically, it's a really difficult risk to manage. I think I probably see that a little bit more because, as you mentioned, Ali, I deal a lot with recruitment businesses and the staffing sector. So there's a lot of contingent labor. There's a lot of people meeting people that they haven't met before in environments outside of the employer's supervision. And the really concerning thing for me about that when I was reading up on it is the liability comes in before the guidance. I don't know if you've got any thoughts on that, Kate, but I mean, that to me seems very counterintuitive to put that responsibility on somebody before telling them what good looks like.
Absolutely.
It doesn't leave us in an easy place as employers, doesn't it? We've got increased liability, not much guidance, and I think you're right, Mark. There's got to be this individual company sort of careful thinking about what the risks are, where they might be, how we train people, and so getting prepared isn't just about HR department, get on with it. This is a whole business challenge, and I think, well, I don't know if you guys would agree with me, but sometimes I see business leaders and business, directors, they get the sort of legal and responsibilities around tax and HMRC responsibilities and financial reporting, but actually the ones around people are definitely feel a bit less important. But we've got significant legislation for people to get their heads round at the moment. So look, we've talked about some of those big ERA changes, but we also know statutory payments are changing and quite soon. Was it last week? So, Kate, back to you. I'm going to share another slide, but if you can talk to us about these statutory payments changing, that'd be fantastic.
Sure. Okay. So you can think of it almost as 2026 is talking about increasing the floor. So higher SSP, broader eligibility, higher redundancy, higher wage costs. And 2027 as removing the ceiling, unfair dismissal compensation becoming open-ended, as we've already discussed. So thinking about the floor, if you like, the statutory sick pay changes have already come into place earlier this month. The actual amount has increased to £123.25 a week. It's now payable from day one, as opposed to day 4, and there's no earnings threshold. So that means many more employees will qualify for SSP. The statutory family-related payments have also increased. So maternity, paternity, adoption, shared parental bereavement, they've gone up to £194.32 a week. National living wage for over 21-year-olds, as you'd expect, has now gone up to £12.71 an hour. The redundancy and tribunal basics, they go up every year. So they've gone up now from a maximum weekly payment of £7.19 to £7.51. And that in turn increases the unfair dismissal cap, which we know will go altogether next year. But at the moment, it's gone up to £123,543. So those are the basic floor related changes. But as we've said, next year we're looking at removing the ceiling as well.
Yeah, great. So some of those probably will already be processed by your payroll. Yeah. We don't have time, unfortunately, to go into some of those conversations around how that day one, somebody doesn't turn up for work on their first day because they're sick and what that means. But those challenges are real, and certainly employers with, huge numbers of staff and on minimum wage, etc. It's a steep learning curve, change, and financial pressure that we're all aware of. Sasha, there is loads for business leaders to keep track of. Can you briefly explain your role as a fractional people director? How do you help with this stuff? Because it can be quite overwhelming.
Yeah. Okay. Well, I typically work with clients about a day a week. And I start by helping clients shape or review their business strategy and then build a practical people plan around it. Covering the key areas, Ali, as you know, people, processes, culture, structure, leadership and talent. I guess lately, yes, we have been focusing on the ERA changes, updating, the policies and the contracts, briefing managers on what's been changed, what is due to change and what will be changing. Going back to some of the things that Mark was talking about, putting in structured recruitment, onboarding and probation processes to help avoid unfair dismissal claims. But also looking at management training programs. I think we've already mentioned it really, that most risk doesn't actually come from the people processes itself. It's actually where businesses are most exposed, in my view anyway, is the everyday management behaviour within the framework. So you can put the framework in place, but you have to have the right behaviours within it. So if you think about things like inconsistent treatment of employees, so different decisions for different things, off the cuff comments, informal WhatsApp messages, you can cross the line for banter quite quickly, like into something that shouldn't be said, or just avoiding difficult conversations. That's for me is where the liability starts to creep in. So I guess top 3 tips really for managing risk going forward would be train managers on conversation skills. So we've been looking at, a lot of clients about how do we train managers to have conversations. Miscommunication drives so many disputes, and banter, as we've already said, can easily really cross the line. I'd also say take the pressure off managers to answer immediately. We know managers feel like they have to be able to answer a question almost as soon as they've been asked it. If you sort of normalise, I'll come back to you on that, it allows them the time to go away and check what other decisions have been made in similar circumstances, and that then drives consistency decision making across the business. And then I'd also get managers to get in the habit of logging decisions and conversations, because I guess if you can't evidence it, it'll cost you going forwards. So then were my 3 top tips, I guess.
Yeah, brilliant, really helpful. And can you also tell us a bit about probation? So 6-month unfair dismissal. So let's just talk about the dates quickly. This is coming in, Kate, isn't it, on the 1st of July?
It is, but actually it's worth pointing out that as of it's coming in 1st of January, but anyone who's been employed for 6 months will have, by the 1st of January, if they've arrived after July, they'll be coming very close to that 6 months. So small distinction, sorry, but it's worth noting.
So 1st of July hires from 2026,
yes,
their
yes.
6-month probation will kick in from the 1st of January
Indeed.
2027. So Sasha, what practical and positive changes are you making for your clients to manage this probation change and this sudden drop of right to permanent employment?
I think if you'd had a robust probation process always had one in there probably isn't much change because you already have that robust thing. I think the legislation is a really good prompt just to tighten things up. Ultimately it comes back to having, the right people in the right seats, Sally, doesn't it? And we know, with the impact that has on actually delivering your business plan. So it is about trying to get you higher, get it right first time. And that is a much bigger topic than we've got time to cover today, I guess. But we've been looking at, so what have I been looking at with clients? Better interviewing. So giving the managers interviewing skills, making sure they know what good looks like, job descriptions, management, competencies, etc. Structured onboarding and induction. So really understanding like the role and the expectations, how to set objectives so they can measure those new employees in that period properly. Regular one-to-ones, standard templates for doing those one-to-ones, structured interview type processes, not just a chat, but a proper checkup about their performance and behaviour. And again, management training on how to give constructive feedback. And I guess if you put all of that in place, then probation becomes a genuine assessment period rather than just a tick box exercise. And I guess that's what protects your business going forward.
Yeah. It's not going to work anymore, is it? To hire somebody, let them do whatever they want for the first couple of months, like Mark was saying, that gentle introductory period, and then think, oh, I really should train this person, and now I've got to see if they're any good, because the clock is going to be ticking, isn't it? And what I certainly wouldn't want to see is more panic firings at 5 months and 3 weeks, which we all know can happen when some of this building blocks isn't in properly. So Yes, it's good to get this stuff right. And look, Kate, everyone loves to hear when it all goes wrong. Can you just, don't scare the living daylights out of us, but have you got a case that you can share with us?
I have. I'm afraid it is a real shocker, and but it's a well-known shocker, and is fortunately very rare as far as I know. So this is Wright Turner and London Borough of Hammersmith and Fulham. It's a 2024 case. What happened was the claimant was hired as a senior director. She was director of public services. She disclosed that, or she was diagnosed with ADHD shortly before she arrived. And she also disclosed that she was suffering from PTSD, and that was due to a former role that she'd had managing in real time the operations at the Grenfell Tower fire. So understandable. Unfortunately, her relationship with her management deteriorated after the disclosure. She had a lot of work to do. The hours were very intense. She went off on sick leave. The employer borough then did things that I'm sure nobody on this session would ever do. They backdated the probation extension letter without discussion at all, and actually backdated the date to make it look as if the extension letter was dated before her probation had expired. They dismissed her at the end of the extended probationary period without actually, because she was still on sick leave, without actually talking to her about the issues, which they said were performance related. So they then backdated the dismissal letter to make it no, to make it earlier than a grievance, the date of a grievance that she brought, quite understandably. So the tribunal described the handling of this as fundamentally dishonest and procedurally improper, which in legal speak is bad. So they found that the extension of probation was disability discrimination, that the dismissal itself was also discriminatory, but for her disability, she wouldn't necessarily have been dismissed, and certainly not on sick leave. The employer had failed to follow even the spirit, let alone the wording of its own probationary procedures. And they agreed that the backdating seriously aggravated the whole case. So importantly, in this case, she had obviously less than a year's service, and indeed less than 6 months service. But she was awarded significant amount. She was awarded for loss of future earnings, pension grossed up for tax. There were significant additional sums for injury to feelings, and in this case, personal injury, because they actually decided, and it is possible for tribunals to make personal injury awards, it's rare, but they decided that the treatment had manifestly exacerbated her conditions. And they also applied the 25% ACAS uplift, and they applied aggravated damages because of the backdating. So I'm sorry, you asked me not to scare you, but she actually was awarded £4.5 million. And this is a London borough.
Yes.
So it's a powerful probationary lesson. It shows
Yeah.
probation isn't a legal safety net. Sloppy processes during probation can escalate rapidly, obviously, where there's a protected characteristic. Attempting to tidy up paperwork afterwards is catastrophic.
Yeah.
And it's not good. And
I've had two questions in, Kate,
okay,
actually. So
yeah,
a very cautionary tale there, but two questions have come in
yeah.
about whether with this 6 month clause, would it be better for companies to think about a 3 or a 4 month probation period to give time post probation to then have a bit more wiggle room? I guess there's a challenge as well, isn't it? Say somebody's 6 months comes up and then the meeting's been bumped or someone's off sick or on holiday and things then just
Absolutely.
sort of drift without
Yeah.
maybe planning that they would. Have you or Sasha got any thoughts on the practicalities of that 6 month cutoff and then what you might do to manage it better?
Yes, and I'm sure Sasha will have thoughts on this, but it's worth really keeping in mind that, as you've said earlier, Ali, you don't have 6 months. You have 5 months and 3 weeks, because the law adds a statutory period of notice of a week to employment when they're looking at unfair dismissal eligibility. So you've got 5 months, 3 weeks, a really awkward amount of time. It makes sense to have a short probationary period with a proper, as Sasha's already said, a proper process of performance management and induction throughout that. A review at the end of the probationary period, which many employers are now putting at 4 months, in my experience, to allow, as you've said, an extension. And yeah.
Yeah. Thank you. That's helpful. Okay, so Mark, we're hearing about all these risks. It would be great to get your take on what can be insured, what can't be insured.
Yeah, I mean, I think the first point to make is insurance is part of the answer. It's not the full answer. All these things that Sasha and Kate have been talking about in terms of best practice and policies and training, etc. All those things are positive underwriting features, right? So being able to get insurance is one thing. Being able to get insurance at a palatable premium that you can stomach paying is the utopian answer. That likelihood will be much greater if you can demonstrate that you're observing all these kind of basic principles of people risk management. I think I might have just made that phrase up. It sounds really good, doesn't it? But you get that kind of general principle, yeah. So yeah, having proper procedures in place is is the people equivalent to having sprinklers in a building. If you're insuring a fire risk. So the insurance available is essentially employment practices liability, right? Which very isn't actually bought in isolation very frequently in the UK. It is more so in America, which shouldn't be surprising given it's historically been a far more litigious environment. In fact, it'd been unthinkable for a services-led business, perhaps in the States, to even think of trading without employment practices liability. More commonly in the UK, it's kind of sold within a broader management liability package, yeah, because obviously management teams, boards of directors, they have broader statutory duties and responsibilities that sit outside of people, and it tends to be a more cost-effective solution in terms of buying that as a package. But at its core, the employment practices liability insurance will provide cover for defence costs. It will provide cover for awards, settlements, the cost of responding to a regulatory intervention or investigation, Fair Work Agency, HMRC, HSE, etc., etc. But like anything, I mean, I'll labour this point, it's a backstop. There is, I'm just going back to one of the points, I can't remember if it was Sasha or Kate made earlier about the reputation element of these disputes as well. So there is support within a goodly crafted policy, and not all policies are created equally. It's like anything, you get what you pay for, but a lot of policies will provide cover in terms of that kind of the costs associated with that also. But there is even when you've got the insurance, there is a financial liability. These policies always have an excess on them. And the reason why they have the excess is fairly obvious. They want to drive a particular standard of behaviour. The excesses tend to start from around about £5,000. So in itself, it's a risk sharing mechanism. But I mean, one of the considerations, even for businesses that are buying in employment practices liability currently, is to factor in the fact that the frequency and the severity is increased for the reasons that we mentioned before. And even if you've already got the insurance, you perhaps should start thinking about the adequacy of the limits that you purchase. I mean, that example Kate gave there was a fairly extreme example, I would say, from the type of and size of claims that we see. But I think the general point is there is going to be inflationary pressures coming into these awards because the protection, which was the cap, has been removed.
Yeah, and it's the time that these things take, isn't it? So even with insurance, it's the time investigating, getting the paperwork together, helping write replies, and yeah, it's you can see why we spent a bit of time talking about settlement agreements earlier on. These things are all connected.
Yeah. The one
Thanks,
thing
Mark.
sorry, the one thing I would add, Ali, before that is what's uncharacteristic about employment claims is the cost to litigate and to actually instigate is actually not that significant. You know, you think about it, you can go to ACAS and incur no cost. And the other complexity now is actually a lot of potential litigants have legal expenses insurance in place unwittingly. Quite often they'll get it as a kind of added frill to home insurance or car insurance, but quite often those policies, which are relatively insignificant costs, which I would argue they haven't spent a lot of time thinking about buying, do actually have cover in there for employment matters.
And adding to that, good old AI, ChatGPT, is very happy to turn complaints into a beautifully long grievance letter claiming all sorts of things. So people have got a lot of help at their fingertips. Sasha, you know, one of the things that you do in terms of how you talk with businesses is that sort of oiling the wheels and trying to manage risk in a sort of day-to-day dialing it down type of role. Can you just tell us what are you seeing out there? What's the sort of early warning systems? How can you help to mitigate some of these risks as you're helping clients week in, week out?
So I guess maybe, Ali, it's not what I can do, but actually I can give you some advice on what businesses can do, and the advice that I would be giving to businesses to help try and mitigate some of this. And it almost sounds too simple, really, but it's about listening to what's going on in the organisation and really listening, not an annual survey that sits in the bottom drawer and nothing's done with it. It's about trying to make listening part of the operation of the business and the way the business actually runs. So you just said it, actually. Listening is your early warning system. It's your cheapest risk management tool that you can have, like going back to Mark, where it doesn't cost you anything to listen to what's going on in your business. The information sometimes that you need to protect your business is almost already inside it. I would say most people know, someone would always know if there's a manager that's being inconsistent or if there's something going on. It's just that is the environment you're creating safe enough for people to come forward and tell you about it? Is it safe enough for people to come forward and say that they're struggling before it becomes a grievance? That type of information, really. So the early warning signals are there. You've just got to have the culture that enables that to come forward. I guess practically, what does that mean? Regular one-to-one meetings, team meetings, pulse surveys, and things that you actually act on, right? So, I mean, because they'll stop telling you, they'll stop being honest if you're not going to do anything with it. Exit interviews, stay interviews, find out why, what would make your best performers leave, and then put mitigations in place. And then if something tricky surfaces, have a conversation on day one. An hour's conversation on day one is far cheaper than having a conversation 6 months later, because that will cost you, going back to where we started, that will probably cost you a settlement agreement if you leave it for the 6 months. So I guess when I'm talking to businesses, it's about actually having a value-led culture rather than a policy-heavy culture, and then making sure that you work within that framework, really. I guess that would be my advice.
Thank you. That's really practical, Sasha. It's it's the thing. Lots of those are sort of, in a way, HR-y things, but actually the purpose of doing them is not just for their own sake. You don't have an exit interview just for its own sake. You have it so that you can learn things and do things differently. And because There's so many, aren't there? There's so
Oh
many
no.
sort of government reviews about learning lessons and how those lessons were missed. And I think probably you're right that all of us as business owners, business leaders have the same challenge, particularly being busy people who've got a day job. And so getting this elevated to sort out, to take action, to tweak things, to improve things, and yeah, for business protection as well as we all know that when employees are engaged, it has a very positive impact on the effort people put in, the productivity, their performance, and how long they're going to stay. So it's not, that's one of the reasons I didn't want this to just be all about risk management, because I think if we can learn those lessons in our organizations, there's so many real positives in terms of opportunity and growth that come out of it as well.
There are, and Ali, can I just say, I think the other thing we should mention is things rarely go wrong overnight. So it's it is really about understanding, isn't it? Understanding what's going on in your business.
Yeah, yeah. So I'm aware we're inching towards the end of our time together, and one of the things I've learned working with entrepreneurs is that everybody has a different risk profile. What you want to ensure, how much you want to listen, what you're going to do about things. And so, I guess we're putting that out there today, aren't we? We're saying we know everybody is different. We do know this ERA 2025 applies to all of us, and we need to make our own informed decisions about what we take forward and what we do as a result. Kate, I'm aware we haven't quite covered off all of the calendar of the changes. Let me just whiz up this slide quickly. She
Sure.
says, getting her brilliant sharing skills. Here we go. So, do you want to just, I
Yeah,
mean, everybody, you
that's
are going to
fine.
get a copy of this, so feel free. You don't need to scribble it down. But Kate, can you just give us a very quick
Yeah.
overview?
So I'm not going to talk about union and industrial action law changes, because I'm going to talk about changes that will affect every UK employer. Major governance changes in 2026. So we've already had the employees who are newly eligible for day one paternity leave and unpaid parental leave. So that's already happened. We also are looking in April at collective redundancy. That's where you have more than 20 employees. As I've already mentioned, protective awards go up to 6 months. So you need to get it right if you're making more than 20 employees redundant. Day one paternity and unpaid parental leave rights. There's a new bereaved paternity leave right for up to 52 weeks. It's unpaid. And that's where fathers have been bereaved with a new baby. Sexual harassment disclosures will now become protected disclosures. So they have become whistleblowing disclosures. So where you've got somebody complaining about sexual harassment or making allegations, you need to be aware that that does give them significantly increased rights. The duty to take proactive steps to prevent harassment now has been changed to all reasonable steps. We don't have the guidance on exactly what all reasonable steps are. As Mark was saying, it's quite difficult, but employers just need to know that they really do need to be concentrating on sexual harassment now and thinking in an intelligent way, knowing their workforce, what steps are needed to be taken to prevent harassment, including third-party harassment. Fair Work Agency has been established, as we've said, in October this year, and this is another thing that will increase the burden on the tribunals in terms of increased unfair dismissal claims or any type of claim. Employees will now have 6 months in which to bring a claim rather than 3. And the way the tribunals are at the moment, they are totally under-resourced and underfunded. I'm getting hearing dates in 2028 now for claims that are being issued. So it's going to really cause a problem within the tribunal system. But we don't want to get claims. We don't even want to get there at all. And in 2027, we're looking at culture and work patterns. Mandatory gender pay gap and menopause action plans for larger employees will come into force. And something we haven't touched on, but is really significant for anyone with 0 hours workers, is that the right to guaranteed hours for 0 hours workers will come into force. including as or in additional to rights to be given reasonable notice of shift cancellations and compensation if reasonable notice isn't given.
Yes. So it's interesting. Someone's made a comment here. In my experience, it sounds like a full review is required, and building out a robust ER strategy is required rather than just focusing on implementing the changes to the ERA. I think that's a really valid point. Thanks, Lisa. It's
absolutely key. An audit, and any of us could help you with an audit of your processes if that's of interest.
Yeah, yeah. So look, I think my question to everybody on the webinar is simply, do you have the skills, the resources, the abilities to deliver this in-house? And if not, please go and find them from somewhere. Prioritize the urgent actions for your business. Who's responsible for what? And are you keeping records? Because we know, for example, the sexual harassment training that you're doing for your teams, if you haven't recorded you're doing it, it's as if it didn't happen. So that means scheduling things like mandatory training so that you haven't lost cases before they've even begun. Think about your wider people strategy. What would it take to get the right people in the right roles to deliver your business plan? And we do kind of have this period through the rest of 2026 to get things in order and make sure we are ready for next year. And as Mark's told us, insurance just can't cover everything, but it is part of your business protection. And is it worth a review? Do you have the right insurances in place? Do you need to review that? So we've got time for a few questions, but before we go into the questions, I just want to say thank you to all of you three. I've really enjoyed talking to you, and all of them would love you to connect with them on LinkedIn, reach out to them. They're really happy to carry on discussing all of this with you. So as we're going into a few questions, we're going to have an ERA, Employment Rights Act 2025 checklist and the slides available. If you would like that, please type just the number 1 with your name in the chat box. If you'd like to have a chat with any of the people on the call today, type a number 2 in that box to say, yes, please, I'd like a chat. And if it's with someone specific, please add their name and we will definitely get in touch with you. So I've got some questions. If you've got any more questions, please pop them into the questions and answers or into the chat box. So here's a question. Who wants to take it? My managers, oh, hold on, the question's disappeared from my brain. My managers handle most of the day-to-day people stuff. How do I make sure they don't accidentally create a liability without knowing it? There we go. So that sounds like a Sasha or a Kate question to kick off.
Well, training, Ali, that we answer it training. We said training on conversation skills, training on the processes, training on the legal position. So it is training, isn't it?
Yeah, it is. It definitely is. But I guess it's training, and then how do you prove they are competent? What do you do before someone becomes a manager? What do you do afterwards? And Mark, I think you raised that point of what's required in the first week or the first month if you're coming straight into a new business as a line manager. What does that mean in this business as opposed to the last one you were in? Kate, I wondered whether you think the Fair Work Agency are going to be really busy with our very biggest employers and whether smaller employers are going to feel as much pressure.
Well, I've not heard anything about them, although they are in existence, and I think it'll take a while for them to get up to speed. But they are going to be handling an awful lot of regulatory issues, national minimum wage, working time. They'll also be able to bring claims on behalf of employees. So they're going to be very busy. And as you've identified, they're therefore only going to be looking, I think, at the larger employers, maybe in the same way as the ICO does at the moment. They don't have the time to deal with the small mistakes that employers make. But watch this space. I should say they're a politically generated body, and if the government changes, they may disappear. So, let's wait and see. But I think you're right. I don't think you need to really be worried about them as small as SMEs at the moment.
Yeah, yeah. Mark, specific question here for you. Can you add employers' practices liability insurance after a claim that would cover that claim, or is it a looking forward type of insurance?
Yeah, I mean, the non-complicated non-complicated answer is it's a looking forward. So most insurance policies, particularly claims-made policies, which employment practices liability are, will exclude known circumstances. The specific mechanism that insurers have to deal with that is they put what's called a retroactive date in the policy. So that's the date after which any claim can be brought.
Yeah. So if the claim comes in afterwards, but the incident happened beforehand, it also won't be covered.
Correct.
Yeah. Yeah, something definitely to look into. Right. I think we will stop there. There's 4 more minutes. I've got one last slide just to pop up, just to let you know about our next webinar, because this is one in a series. So our next webinar is, there we go, 20th of May, same time, over lunch, and we're going to be talking about Scale Up Masterclass, proven systems, structures and strategies for accelerated growth. And hopefully you can join us then, and you can also share this recording with anybody you think might find it useful. Certainly if you think within your organisation people aren't aware enough of the changes that are coming in and the Employment Rights Act, please do share the recording. We're really keen, all of us, for everybody leading businesses and director level and everyone in HR, really important that they know about these changes coming in, as it is for everybody who's a manager. So please do feel free to share this. And thank you so much to Kate, to Mark and to Sasha. It's been really great chatting to you, and carry on spreading the word about the ERA.
Thank you.
Right. Thank you.
Thanks everybody for joining us. See you next time. If anybody does want to know any more on a one-to-one basis, we'll be in touch with the recording and slides. Thank you.